Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Kathy Gillespie,
with students
Dakari Chapman
and me, Tova Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America.
I am founder and co-president of Constituting America, and welcome to this very exciting series that we're starting today on natural law. What is natural law? Well, as Professor Knipprath said, backed by popular demand, we don't exactly know. A lot of people think differently about what natural law is, but we are going to discuss it today and try to pin it down and focus on it. And it's very, very, very important because I believe personally we're losing it in our society today. So welcome, come on in. We'd love to know how old you are so we can gear our chat toward your age. So let us know. We'd like to know how young our audience is today. I'm an actress by trade, but as I said, I'm founder and co-president of Constituting America. And co-president is the one and the only glorious Kathy Gillespie, who was a chief of staff on the Hill for decades, and she is now one of the 16 private citizens that has been chosen to the chair, but she's on the commission of the semi-quincentennial celebration, which is happening in 2026. So she's helping plan the celebrations for 2026, just so you know. And she was also chair of the, what do you call it, Kathy? The president's, I'm doing this by memory, the White House Fellows, which is a very, very big deal. So Kathy Gillespie, welcome to the show. You're going to talk about our sponsor today. So come on in and talk to us.
Yes, thank you, Janine. Thank you for that introduction. I want to thank our sponsors today, Jonathan and Betsy Nash of Houston, Texas. Jonathan and Betsy are longtime supporters of Constituting America's, great friends of mine. And Betsy even attended one of Constituting America's short film premieres in Dallas in 2013, the Constitution reality show style. Jonathan is a regular attendee on our constitutional chats and often contributes questions and comments. So thank you, Jonathan and Betsy, for your generous support of our constitutional chats.
Yes, thank you so much. All righty. So I'm going to introduce the rest of our panel so we can get straight to the constitutional expert, Professor Knipprath, with us today. Okay, so Tova Love Kaplan is an extraordinary young woman. I think so incredibly highly of her. She has won our contest 3 times, our We the Future contest, for best entrepreneurial category, where she created a marketing plan, and then best short film, and then she won for best app, or whatever you call it, STEM, because we have an app that we're getting ready to put up on for Constituting America. And she is 17 years old, from Chicago. I like to say that she runs our National Youth Advisory Board, because she is the president of the National Youth, what do we call it? The National Youth Director for Constituting America. And she runs that like a CEO of a top 100 company. She also is I believe she's fluent in Arabic and wants to, you can tell us about that. And I think that's just amazing. And she, I believe, is very interested in global affairs, and we may see her as the American ambassador at the United Nations someday, or Secretary of State. I don't doubt it for 1 second. Tova Love Kaplan, say hello.
Thank you so much. Yeah, I am studying Arabic right now in community college. So just working on that, as well as Hebrew and Latin and French. So just trying to learn all the languages. But yeah, thank you so much for having me on. It's always such a pleasure. I can't believe we've been doing this for over a year now. My quarantine would not even be half as good without Constituting America and all of these amazing weekly content that we are able to produce for people. And thank you so much to our sponsors who make it possible. And enjoy the show, everyone.
Oh my gosh, Tova, you speak 4 languages? Wow, you're the new John Quincy Adams, aren't you? You spoke all those languages. That's impressive. Someday we'll have to speak French together. Okay. Now, Jewel and Joerg Gilbert, the extraordinary Jewel and Joerg Gilbert. We're so thrilled they're with us now. I believe this is their third show co-hosting with us. And Jewel and Joerg have also won our contest, incredibly talented, and starred in our documentaries. Jewel Gilbert is executive producer, and Joerg Gilbert is operations director of Sing for America, a family-based company that they both co-founded. Sing for America seeks to show the art of truth and light through live performances. Both are proud former We the People contest winners, and Sing for America is an actor-run theater company which specializes in semi-professional musicals, private training in the arts, school drama solutions, and I wonder what school drama solutions are. That sounds cool. And public entertainment events, all while revealing a colorblind world stage. Jewel and Joerg are graduates of Moravian College. I believe I'm saying that right, because the first day I said Moravian. I know Moravian. You can correct me. College, where they earned a BA in musical performance and dramatic production. And boy, both of you won. I believe Jewel, you won first for best speech, and then Joerg, you won for best PSA, and I believe you won other times. You'll have to remind us. And we've been on trips together, and you both are just extraordinary young men. So welcome to the show. You want to say howdy?
Hey, everybody. Happy to be here again. Already have learned so much from our guests and from talking to all of you, and we're enjoying this. Yes, I went on 2 trips. Both of them were awesome. And Jordan actually came with me the first time, even though he didn't enter that contest. We went to LA, and that was very cool. And then Jordan won for what?
I won PSA and Jewel won speech at the same time, and we went to Austin, Texas.
So we got to see we got to see Austin, Texas, and we got to see LA with Constituting America. And I think that's actually the first time either of us went to California or even west of Texas. Our sisters had gone multiple times. We have 3 older sisters, but we never got to until I wrote a speech.
Well, no, those trips were so much fun. Oh my gosh, we got to go on the set with Gary Sinise. Yeah, it was really cool. Well, we're thrilled that y'all are with us and you're getting rave reviews. So thank you so much. I'm going to introduce Aubrey toward the end. Aubrey is a delight, and we're thrilled that she's with us. Well, Aubrey, just say hello really quickly. I don't want to. Aubrey is on our team as media director. You have a picture of yourself, Aubrey? And she's media director responsible for all of our fabulous technology and editing. And she won this year's We the Future Best College STEM Award. She's from Utah, the middle of 7 children. We often ponder about how cool that is. And she's a student at Brigham Young University and aspires to be an athletic coach. Say hello, Aubrey.
Hello, everyone. Yeah, I just want to put in a quick plug to check out our website with more information about the We the Future contest. It gives a great scholarship that helps with school and starts from elementary school on. So it's an awesome opportunity.
Thank you. I'm so glad you plugged that for us. I think all of you are a great testament to the contest, and also just by your presence and your talent and what you've created. But also, if you missed these at 2:00, they're available on social media and on the website and all over Apple, Spotify, you name it. You can revisit these shows. All righty, drum roll, please. I think Professor Knipprath just has to be a fellow at this point. I think fellows are usually paid, but he's our one and only distinguished fellow. We're thrilled to have Professor Knipprath with us again today. Let me tell you how extraordinary he is. Professor Knipprath teaches constitutional law, legal history, jurisprudence, and various business law courses at Southwestern Law School in Los Angeles, and we have been there. He is the faculty advisor to the Federalist Society and the Christian Legal Society at Southwestern. He is one of Constituting America's constitutional scholars and has been writing essays for our 90-day studies. We have one going on right now on the Declaration of Independence. Just go to Constituting America, it's right there. We have amazing studies, and they're all archived. 90-day studies, we're talking about the Declaration of Independence. He's been writing with us since 2010, so we've known him for 11 years. Professor Knipprath has written more essays for Constituting America than any other essayist. He's written over 116 for us throughout our 10 90-day studies. Professor Knipprath, not only is that extraordinary, and are your essays the impetus for one of you, this essay is just an impetus for the whole series that we're doing right now, because your essays are always so intriguing and brilliant. And scholarly, and but you volunteer for us, and I just really want to thank you for all the time that you have given us and volunteered. And even when Juliet wrote her book, Our Constitution Rocks, you walked through the final draft for 8 hours. I believe we're on the phone for something like 8 hours going through that draft of our Constitution Rocks. So Professor Knipprath, thank you for being with us here again today.
It's my pleasure. And really, this is such a great project. What you are doing is so important to not just the young people of America, but I think to the American people generally. I just wish everybody were sitting through these courses. So great thing. Thank you for having me.
Well, thanks for being here. And okay, so natural law. I have your essay here, right here. Everyone can well, there are many essays, but this one is essay 6. And it's the Declaration of Independence and necessity of dissolving political bans or breaking down the Constitution. And I've highlighted all these things I want to talk to you about today. But natural law, I had someone, Professor Knipprath, walk up to me and say, he had this earnest look, and he was probably about my age going to law school. And he said to me, they don't teach natural law in law school anymore. They don't teach natural law. And there's something that I starred, and you're going to give us your kind of opening remarks, but it talks about the difference. Hobbes, who was a suspected atheist, he said that he kind of went out of natural law, which was based on our great philosophers like Aristotle, which we're going to talk about today, and God. But Hobbes said that really the social contract and the way we have our laws based on fear. And I think that's really interesting. I always love to correlate what happened then with what's happening now. And I do believe that what's happening in our society now is our law is really based out of fear, and we're losing that natural law based on the classics and on our creator. So we lose that. We've lost a lot. And then you talk about Locke, and how John Locke, really kept the element of creator and God in his philosophy around the late 1600s. And that's what really inspired Thomas Jefferson. So, okay, I kind of teed you up there. And if you can talk to us about natural law, what it is, and Professor Knipprath, talk about for a second, what kind of law is being taught today? I don't really know what that gentleman meant when he said that it used to be natural law and now it's not natural law. I guess it's a more progressive form of law, or a law of, I don't know, whatever. You can tell us. All right. So I look forward to hearing your opening remarks.
Okay, well, thank you, Janine. You've just raised a whole panoply of topics. This could take a whole seminar to cover. I'm going to just start with a very basic question about natural law. Asking this: how exactly is the IRS different from a highwayman? How exactly are police different from an armed thug that tries to get you to do something? So moving away from this very provocative phrasing, right, the question here is, why do we owe political obligation, legal obligation to the state? And this is something that philosophers have addressed now in the West for 2,500 years, going back to people such as Plato and Aristotle, and indeed even to the pre-Socratics. Why do we owe this loyalty to the state? Now, one argument could be, well, it's just on the basis of fear or power. But that's not a good argument, because no state wants to say, well, no government wants to say we can do this because we have more guns than you do. The state always tries to justify, people in government try to justify their actions on the basis of ethics or morality. So here's where the natural law comes in. It seeks to provide an ethical basis for the state. Now, you mentioned Hobbes and Locke and the idea of consent of the governed. That is another line of reasoning for the ethical basis of the state, why the state's actions are just and they are owed our obedience. But the natural law approach, or higher law approach, is something that goes back to the ancient Greeks, has a much longer pedigree than the consent of the governed theory. So natural law is a type of higher law, and there have been numbers, and we can talk about this during the hour, but there have been a number of definitions of natural laws. I think the best one that applies to our topic today is this idea that there is a sort of universal moral law that's out there that controls the actions of individuals including those who are in charge of the community, those who are governors. Now, Aristotle, to try to bring this down to Aristotle, Aristotle is sometimes referred to as the father of natural law. Now, it's a little bit misleading because Aristotle, like the Greeks generally, were not big on jurisprudence and law. They were more into metaphysics, into philosophy. It's the Romans and the Stoics that really brought this down more to the idea of natural law. But Aristotle's a pretty good stand-in because he talked about principles of natural justice. And to understand what he meant by principles of natural justice, it's important to remember that both Aristotle and Plato saw man as flourishing in the polis, in the state, that because man was a social creature. So there was never really a divide, a distinction between the individual and the community, that it required just or virtuous individuals to create a just or virtuous community, and just and virtuous individuals could only be produced in a just and virtuous community. So everything there was connected between the individual and the state. In Aristotle's philosophy, everything had an essence or a nature. What it sought to do was to fulfill its nature. So a dog seeks to fulfill the nature of what it means to be a dog. A stone seeks to fulfill its nature of when you drop it, it falls to the earth. In the same way, humans have an essence, have a nature, and they seek to fulfill that. When a human creates something, a chair, the human has something in his mind as to the form or essence of what a chair is and seeks to craft that chair to meet that nature. So everything has a nature, and in that nature, teleologically or through that nature, seeks to accomplish its ultimate purpose, so its final form. And so it is with the law. The law seeks to accomplish or to achieve the end of natural justice. And it does that by creating or producing legal justice. And it has all kinds of definitions of what legal justice are. But legal justice through the law seeks to accomplish this universal principle of natural justice, because that's the purpose of the law, that's its nature, that is what it seeks to achieve. So it's a kind of universal goal that doesn't change over time. It doesn't change from place to place. It has this universality to it. Individual societies or individual laws may more or less reflect that universality. So you can have bad laws and you can have good laws. If we didn't have that outside standard of natural justice or natural law to judge the human law by, then we couldn't talk about good law or bad law other than how we happen to feel about it. So the natural concept of natural justice and more expansively, the concept of natural law then provides a standard towards which human law not only will trend, but we can determine how good human law is. So, and this is a principle that sets, as I said, is universal, has been around for a long time. Aristotle himself cited to a play by Sophocles in the Oedipus cycle called Antigone. Let me just read a brief passage from that play to show how that interaction between law and human law and natural law works. And the scene is, of course, that Antigone has two brothers, one fighting for Thebes, the patriot, the other one having fought for Thebes as enemies. The two brothers had engaged in a duel. They both died in this. And so the patriot brother is given this wonderful state funeral, but the traitorous brother is left in the dust and the earth to be devoured by the animals. And in Greek tradition, you couldn't reach the underworld in peace if you were not buried. So Antigone goes out at dusk, sort of furtively, and throws some dust on her dead brother's body to allow his soul to go to the underworld. And she's caught. So the king had issued a decree that there shall not be a burial of this traitor. All right, so now the king is facing Antigone. King Creon says, tell me briefly, had you heard my proclamation touching this matter? Antigone replies, it was public. Could I help hearing it? Creon replies, and yet you dare defy the law. Antigone states, I dared. It was not God's proclamation. That final justice that rules the world below makes no such laws. Your edict, king, was strong, but all your strength is weakness itself against the immortal, unrecorded laws of God. They are not merely now, they were and shall be operative forever, beyond man utterly. And she goes on. So this natural law, according to Aristotle and the Greeks, was something that was that we recognize through our moral capabilities and capacities, our moral sensibilities. And that's a doctrine that's also in Christian law, right? That God has inscribed this law on our hearts. So it's something that the natural law reflects this innate sense of morality, and that human law, in order to be, at least in broad principles, be valid, must therefore also conform to our natural inborn sense of morality. And that implies, of course, in all this writing, a lawgiver who has written this law. And even the Stoics and even Aristotle and even Sophocles here doesn't talk about the gods, talks about God. So there is the connection between divine law and the existence of God on the one hand, and this universal natural law. All right, so let me stop here so that we can have time to talk about this more in detail. Very brief introduction.
You said God, not gods. So they were referring to a god, a singular god, not gods, because we know in the Greek philosophy, in the Greek world, they have a lot of gods. Did you just say that? God, not gods?
That's correct. Aristotle refers to Sophocles, refers to that way. Cicero referred to it that way, which is very interesting.
Yeah.
That they didn't refer to gods, but to this. Now, I don't want to suggest here that this was the Christian God, that
Right.
they had other conceptions of what this force might be. It's not the personal Christian God. I don't want to overstate this, but the idea is that there is this uncaused cause who controls all of this, so beyond humans. Yeah. It's not just humans that control this.
And what Antigone was saying was, hey, you may be the king and you've made a law, but what supersedes that law is God and what's going to happen to this soul. So it's really, that's fascinating. That's really cool that you gave us that example. There's something beyond just the edict from mankind, and there's more to life than that. Okay, I think that sums it up really well. That's why you read it. But then that's what natural law is, and that's natural law has to be built on, because you keep bringing up the word justice, and you don't have. I mean, what are people's definition of justice? And so what I think is interesting is if you go back to Aristotle, there was a god, or Sophocles, and then with John Locke, there was a god. And, with the founders, there was God. That was kind of the superseded everything with the top, the dome of the, but where are we today? Where is our law today? Because I think there's obviously a progression away from this type of law. Is there not? I mean, what did that man mean when he said to me, they don't teach natural law in college anymore, in law school anymore?
Okay, the reason for that is because law school is basically a trade school. It's teaching you a trade or a profession, if we want to be kind. The idea here is to teach you how to deal with criminal statutes, criminal law, how to deal with civil law, how to deal with divorces, whatever it might be. Natural law is still taught, oftentimes in jurisprudence courses, specialized courses about the science of law, the philosophy of law. I teach aspects of natural law in the context of constitutional law. And the reason for that is because we do still find remnants of natural law type thinking in some of the Supreme Court opinions, some writings of Supreme Court justices, as well as natural rights, which is a slightly different formulation, natural rights reasoning in many of the decisions of the court, whether or not the court's correct or incorrect on this, as a matter of natural rights, but you find that argument in some of these decisions where the court is referring to unenumerated rights in the Constitution. Where do these come from? And the court may refer to sort of broad fundamental principles of free government, or they may refer to our legal customs and traditions, how we've always done things. And how we've always done things is the essence of that Aristotelian inquiry. And as well as what Sophocles was talking about, the ancient customs of how we have done things in our law, that gives meaning to the Constitution itself. So you still find some of that natural law, natural rights reasoning in some of the court opinions, whether they'll admit to it or not. You found more of it in the early Supreme Court opinions back 200 years ago. But you still see it today, although they won't call it that, because natural law and natural rights reasoning was seen at one point as too conservative, as too restrictive of innovation. And that's a bad rap, frankly. But you know, in the 20th century was all about what's called legal positivism. The state power, its law, when the state makes it the combination of law and policy versus law is something that may restrain policy, especially higher law may restrain policy because it's not good for human beings. Whereas today it's all based on really outcome, utilitarianism.
Yeah. Okay. I want to toss this to Tova, but I think if you compare today's jurisprudence with Aristotle time, I think what I feel we're drifting into today is who is the moral compass of justice. And it's what Antigone was saying. Well, you may be man and you have your realm of justice, but there's a layer above you. There's, immorality or eternity or, a God above you. And so where is justice? How is justice being defined today? And I think we're in a danger zone if justice is being defined by just human thinking, the way the king, what was the king's name?
Creon, King Creon.
King Creon. Okay, so I think we're doing a lot of King Creon thinking today in our law and not a lot of Antigone thinking in our law. And I think our founders were more in the camp of Antigone, because otherwise who defines justice? So I'm going to toss this to Tova in a second, but my last question, and everybody else can join this discussion. I guess my last question is, what is our compass, our moral compass for justice? And that's what worries me today.
Oh,
and
okay.
then I'm going to go to Tova.
So the problem here is you identified a real problem in society. And that is the sort of, in the law, what we refer to as the critical legal studies programs, and going beyond that, the legal realists, and beyond that, before that, the normative positivists. That we shouldn't be asking these bigger questions, that we need to focus more on policy. Well, it's gotten worse today because the assumption almost is that there is no such thing as truth. It's this very hypercritical approach to standards and norms, a heightened relativism, and what in the past has been called nominalism, a reference to that all these things are simply artificial constructs, that the law is an artificial construct, everything human is put together is culturally determined and simply an artificial construct for that culture. And what's interesting about that is that was the criticism that was leveled against the so-called pre-Socratics back in Plato's and Aristotle's time. That Socrates and Plato and Aristotle in different ways we're reacting against that hyper relativism, that sort of argument that there's nothing permanent that is determined, that determines what we do. It's all a matter simply of our choice. So a man, as one of the pre-Socratics pointed out, man is the measure of all things. All right, so everything we do is an artificial construct. There is no such thing as a permanent truth. And that's what Socrates, Aristotle, and Plato and others were reacting against. And that's the problem.
Man, okay. Yes, that's where I think we are today. We're in a society today where man is the measure of all things. And I think that's going to bring great defeat in my personal opinion. Man is the measure of all.
That sets in.
Huh?
Is ultra, sort of skeptical approach or almost cynical approach to things has no way of sustaining itself. There will be a reaction. The only question is when and how that reaction occurs. But there always will be.
Right. We're in the King Creon and we need to get to the Antigone. Interesting that Antigone was a woman. I never really realized that Antigone was a woman. I guess I haven't actually really read the play, but how cool. It was a woman who took the stand. Okay, Tova, your turn. Thank you, Professor Knipprath. This is great. And man is the measure of all things. This is going to be our doom as far as I'm concerned. Okay, Tova, go ahead.
Sure, thank you. This is fascinating. Makes me want to study the topic more. So how are American philosophies and like the philosophy we founded our Constitution with and American conceptions of natural law, how did those differ from British conceptions of natural law and liberty that we were breaking away from?
The American conception of a philosophical basis of thinking is actually owes a lot to the British antecedents, both in the United States and in Britain. With the advent of modernity, there was a kind of shifting away from the classic views of natural law, because natural law implies an order of things, right? That is ordered by this law, and that we're all part of this order. Well, with the Renaissance and the coming of modernity in Europe, again, we start to focus more on individual decision making, on man being the measure of all things. That's where this movement began. That's the big dividing line between medieval and ancients on the one hand, and then modern times on the other. So we began to focus in the social contract theorists on the basis of the ethical state being consent of the governed, okay? And if you read the Declaration of Independence, there's a lot of that in there, consent of the governed. A big difference was between the English and the American conception in 1776 was exactly what did that mean, consent of the governed. The Americans also were more emphatic on the essential human nature of rights, that we all have this by God, versus the English view of things as derived from Magna Carta and through the operation of the common law. So it was a little bit less individualistic than the American approach, right? That the Magna Carta, after all, was the king grants these rights. It wasn't that they had these rights inherently. So the Americans were a little bit more, in that sense, individualistic and in this natural rights approach than the English were. But both sides, the Americans and the English, along with the rest of the West, had moved away from the traditional classic view of natural law, right? Everything was now natural rights. Now, Locke had to consider, where did these natural rights come from? And he borrowed from natural law reasoning. Why? Because in order to have natural rights, you have to be a rights-bearing creature, someone who is capable of exercising those rights. Otherwise, it makes no sense to talk about the natural rights of a cat, much as my cat might disagree. That doesn't make sense, because a cat can't exercise natural rights, can't act within the social order where one could say, yes, this is a rights-bearing creature, but human beings can't. And so in that sense, Locke recognized that, that there is this law that applies in the state of nature, right, that governs all things out there. But Locke made a bigger distinction between that law of nature and the civil law, which governs when we enter society. But some of that law of nature, that natural law, is retained through our natural rights that we do not lose when we enter political society, right? The classic Greek view was that there's no real difference between political society and anything else. We are social creatures, and the polis, the community, is all one: religious, social, economic, etc. Locke and some of the American writers in the Declaration of Independence and so on and so forth, Locke's followers, tried to create a separation between the political commonwealth and the pre-existing society, human society in the state of nature, and that the political commonwealth was created purely by consent of the government. It wasn't something we were born into.
I'm just trying to understand like the concept of natural law, since I haven't really heard much about it before. Is it necessarily a religious concept? Like, do you necessarily have to believe in one divine power, a divine power, to believe in natural law? Or is it compatible with atheism or other philosophies that maybe don't believe in one power? And then how does it connected to or combines with a society that has freedom of religion?
So the short answer is going to be, no, you cannot have natural law without some kind of divine force. It doesn't have to be necessarily one's perception of a Christian God. It can be universal in that sense. But you can't get away from some extra-human or superhuman, suprahuman force. Now, in a Christian sense, we would say that's the Christian God, and Christian Aristotelians like Thomas Aquinas spend time discussing exactly that.
How is that conception of natural law that requires a divine force, which is the foundation of, our country, as you were mentioning, how is that compatible with the governmental system that the same founding fathers that believed in natural law also included freedom of religion? So how did those two concepts connect? Do they contradict each other, or do they reinforce each other?
It doesn't conflict with freedom of religion, because there's no specific sect or denomination that's required in order to apply principles of natural law. You just can't get away from some kind of suprahuman entity, some uncaused cause, uncaused causer, who creates this law, right? If you believe natural law, there's got to be a lawgiver for law to exist. Something must have created this order, this law. Otherwise, it's just whatever you think, whatever you feel. It's not an objective order.
So
but it doesn't conflict with free exercise of religion. You can still be a Presbyterian, you can be a Jew, you can be a Muslim,
But what about people who are atheist or maybe polytheistic? Where does the consent of the governed from them arise from if they don't believe in a, rights granting higher power?
Well, consent of the governed is a different thing. It's a different way of legitimizing the ethics of the state or the ethical state. But yes, if you're an atheist, you're going to have a tough time coming up with the natural order, because you can say, yes, there is a natural law that controls us, but how do you know what that natural law is? Where does that come from? It can't come from you, because you can't be both the creator and the creature.
Yeah, and interesting. I'll just say a note to great questions, Tova. It doesn't say freedom from religion. It says freedom of religion. So people can be free from religion if they want to be, but it's free. It really was freedom of religion. So people get that confused quite often. Okay, go ahead, Julian Jordan, your turn.
All right, so definitely love this topic. I got to read my question just so I make sure I get the wording right. But my first one. So your article points to the development from social contract theory or social compact theory into a turn to the subject. And I would also identify then that we could look to that into a development of placing the civil rights above natural rights in a constructivist way. And so today, inverting power back to the government from the governed. So almost as if it's turned on its head. This is something that we almost assumed in the college classroom as I just recently graduated. And my question is that, is there a way to reconcile Locke's idea, which married the consent of the governed and universal moral law, without giving any ethical foundation to constructive theorists or modern failings?
Okay, so very complicated question. I think you're right that today there is, if I understand the question correctly, that there's been really a reversal of the earlier thinking, that it's much more like, okay, we've surrendered these powers to the government, and it's the government that's creating these rights and these benefits for us. That's what determines our rights. What I tell my students is that natural law type or natural rights type thinking doesn't go away. It's still there. We are still have that same moral law inscribed on us. It's not easy oftentimes to find out what the natural law means. That doesn't mean it doesn't exist just because it's difficult for us to figure out. But we as citizens have an obligation to hold the government's feet to the fire. We as citizens have an obligation to involve ourselves, and we can use principles of natural law to challenge government action. But it requires thinking, it requires hard work. So it's not something easy that comes along, but it's, I think, incumbent upon a citizen in a republic, and we can go, that's a whole nother line of discussion, to hold the government's feet to the fire by judging their actions in terms of these higher moral laws.
And also in the article, it referred to a philosophical break between Locke and Aquinas. And Locke is able to justify revolution partially because of this break. Could you maybe just talk about that for a second, as far as what was the objection exactly that he was justifying it against, or how significant is that break, or whatever, just briefly significant that is? Because reading it stopped me, but I don't know if I understand it.
Okay, so a number of things there. Aquinas is writing during medieval times, a time of great sort of instability politically, with Viking raids and so on and so forth. And I'm not going to get into all that. But going back to the classic Aristotelian view of things, which is what Aquinas was also talking about, the individual lives within the community, and it's a communitarian theory, right? So you don't have a right to revolt against that order. From Aquinas' thinking, the state is ordained by God for man's well-being. So you don't have a right to revolt against that. You have a right to challenge what the state do. You have a right to pray to God to enlighten the ruler and all of that. But you can't revolt. Reflecting both philosophical concerns as well as practical concerns given the relative insecurity of the society. Well, what happens with the turn to the subject, where now the basis of the ethical state is consent of the governed, not some external order, but it's the consent of the governed. Now, under the social compact theory, now when the state fails to apply or comply with the social compact, its obligations, then we have certain rights. And at the very end of them is potentially, and he's ambiguous about this, Locke is ambiguous about it, but suggests that there is a right of revolution. Remember, Locke is justifying, basically, in so many ways, the Glorious Revolution in England, Glorious Revolution of 1688. If you read the Declaration of Independence, when Jefferson's writing there, you can't do it for trivial causes. You can't do it hastily. You have to wait and wait and wait and try everything you can before you resort to this right of revolution. That's exactly what Locke was saying, right? That it's not something to be done lightly. You got to try other things first. It's not something you do for trivial reasons, even if the government has kind of sort of trivially breached the contract. But that's the difference between Locke and Aquinas, is that Locke was more individually focused there, based on the subjective consent of the governed, individual free will, versus Aquinas's view, the classic Aristotelian view, that man lives within a community, and that is a communitarian, non-individualistic view of the relation of the individual to the community.
Okay, Joerg, let's get your questions in, because I want to give Kathy a solid 10 minutes here. So
all right,
we have, go ahead.
So just to split up a few definitions. We heard of natural law, natural justice, and I want to hear a little bit about human nature. So where do those all coexist with each other, and what do you think are some important differences, if there are any, to those three?
Well, people like Aristotle and Aquinas, and I think, again, Locke and folks like that, who were fairly, moderate as far as sort of in their modernistic thinking, they would agree that there is such a thing as human nature. Now, and that we have these moral sensibilities, right? This was something even in the 18th century in the Enlightenment that any number of writers, including Adam Smith, agreed with. Today, we oftentimes reject the whole idea of human nature, right? We are much more nominalist in that way, that there are no such things as essences that drive the way we act, that we naturally tend to try to comply with human nature, follow that which is good. Now, one of the issues that always came up is whether or not law exists to control human nature, or whether law is consistent with human nature. And that's a debate that, is not going to get settled. The idea, though, was behind the more optimistic views of natural law or natural justice, Aristotle, Aquinas, and so on, was that this natural law conforms with human nature, and human nature, what humans do, is evidence of the existence and the meaning of natural law and natural justice. Now, that doesn't mean that whatever humans do is okay. But if we look at human experience over time and across cultures, and we can discover a universality that tells us that this is probably a universal principle at work. And that which humans do consistently in many different areas, we can argue is naturally for their human betterment, because humans are attracted to the good and are repelled by the bad as a general principle. So that's how, natural law, natural justice, and human nature, in a very brief comment here, can overlap. And human experience becomes the key in all of this.
Our founding fathers often spoke about God and their role in the formation of the country. And it seems it was a very crucial aspect of the Declaration and the Constitution, that they are rooted in God's design for man. Now, if our leaders are violating those laws today, can we still say that we are truly a nation that puts God first, as we were founded to be?
There is a difference between the rulers and the people. And the very basis of social contract thinking is that the rulers might well err, that they may deviate from the proper path. But that doesn't mean that individuals necessarily are going to deviate from that path. Now, I'm not going to say that isn't an interaction between how the rulers act and how the people, what the people believe. And certainly there is that concern about that, what we might refer to as moral rot. And that also ties in, now connects it to the classic view of the interrelationship between the individual and the society. As I said at the beginning, the Greek view that a just society requires just individuals and goes in the other direction as well. This is a theory of classic republicanism. John Adams talked about this in his writings. The other framers talked about this in their writings, the connection between a virtuous society and virtuous individuals. So I think there is a sort of downhill effect that reinforce each other if the leaders and the elites, don't comply with those or don't reflect those eternal principles.
Yeah, and haven't we seen that happen with communism? I think the rise and fall of the communist nation in Russia and things of that nature, when they start cutting out any sort of, when they believe in communism, that man is the measure of all things, that gets really dangerous. Because as our founders say, men are not angels. So it's going to be a problem. Kathy, go ahead.
Well, thank you, Professor Knipprath. I wanted to ask a few audience questions because we have a lot of audience questions coming in. And Sandy Thatcher asks a really interesting question, asking why natural law did not find its roots in Plato rather than Aristotle. And Sandy saying that Plato believed there was a metaphysical basis for morality in the realm of ideas that gave it a semi-religious flavor. And he goes on to state that somewhere along the way, Aristotle became associated with democracy, while Plato became more associated with authoritarianism. And I'd never heard that. And I was just curious what your take was on that.
All those statements are correct. Now there's a connection between Plato and Aristotle. Aristotle was Plato's student. Plato was Socrates' student. So there's going to be a connection between the two. But Plato approached it in a more metaphysical and intellectual way than Aristotle did. Plato, in that sense, was more a philosopher. Aristotle, remember, is a marine biologist. He's a scientist. So he's going to approach things differently from his perspective, more down to earth than Plato. Plato had this separate world of the world of ideas. Idea meaning that which you perceive through your mind, through your mind's eye is what that meant in Greek. So this world of forms or ideas was this, in a sense, real world that existed out there towards which we all tried to go, towards which we tended. Aristotle found the form inside the thing itself. All right, so the form of what an oak is going to be is in the acorn itself. It's not some form of oak that's in some separate world of ideas. It's natural, it's inside us. So that's a difference between Plato. He brought it down to earth, right? Now, as far as democracy versus authoritarianism, again, there's less, that's true. That's how oftentimes they are perceived. But there's less there than meets the eye, because neither one of them was particularly enamored of democracy, right? They just approached it differently. Plato, through this idea of this ideal republic in his work Politeia, but there's a question whether that was supposed to be kind of a blueprint or was sort of a horror story. This is what's going to happen if man tries to create this perfect republic. You're going to have terrible things happen, and it's not going to work anyway. Whereas Aristotle was more, okay, let's look at all these different governments. He did all these studies, or his students actually did, and see what works best here. What would be the best ideal form? What would be the best practical form? And he came up with a sort of mixed government, of a balance between elites and the people. So yeah, we have to some extent distorted what Plato and Aristotle really wrote.
I just want to say, Senator Thatcher, that was a great question, and that was a great answer, Professor Knipprath. I love Plato. See my book on Plato? There, Plato, right there. Plato. Plato's my guy. I love Plato. Okay, go ahead, Kathy.
Well, I was also curious. I know you talk about natural law in your law classes, I'm sure, whenever you can. I have two parts to this question, but when your students come into your classroom, do you find that many of them have any history of learning about natural law, either in previous college classes or previous high school or middle school classes? And then I wanted to give a shout out to one of our best Constitution lesson plan winners, teacher, Aletta Brandstetter, who sent us a great chart. And she said that she has a lesson plan called Our Nation's Foundations Lessons for Intermediate Students. She has a wonderful chart that she shows, and she has natural law at the very bottom of the chart. And she teaches her students that that's the bedrock of our government. And then right above that, she has consent of the governed. And then on top of that, she has the checks and balances. And I wanted to see, what you think students are learning about generally about natural law before they get to you, and then also what you think about Aletta's description of natural law as the bedrock of our government.
Well, a real thank you to the teacher for doing that. Her students are really in good hands there. Most students, unless they've taken philosophy like Jewel and Jorn have, they probably have no background in this whatsoever, right? I sometimes despair whether these folks coming to my classes have learned that there is such a thing as the United States House of Representatives and the United States Senate. So I'm not even necessarily worried about whether they know about anything about natural law. But yes, college education, I think, generally is deficient in preparing people for law school, for that aspect of it. And yes, natural law and the consent of the governed, there is a connection as in Locke, the state of nature is governed by natural law. And the distinction between natural law and natural rights is not an absolute one, because rights arise out of this natural law. So if the natural law is in the state of nature that I will seek to survive, I have a duty to do certain things. I also have a right then to do certain things. But there is also a difference in the sense between the consent of the governed and the natural law, in that the consent of the governed focuses on the willful actions, voluntary actions of individuals, versus, as I said before, it's more individualistic. Whereas the natural law idea is we're part of an order, whether we like it or not, we are part of this order. And therefore it's more, in a sense, communitarian oriented.
Okay. And then finally, bringing it to today, Dwayne Horner asks, is there a correlation between natural law and strict constructionists? Someone you might use an example would be Clarence Thomas or Antonin Scalia, strict constructionists on the Supreme Court.
I would say no. And I'm going to give you, and I say this to my students, and then when we discuss the nature of rights, and then eventually we get to an opinion where Justice Scalia basically says the same thing. And that's this, that he distinguishes between the citizen involved in politics or a politician versus a judge. And Scalia would be a strict constructionist in the sense that he would say that the only thing I can look to as a judge is the Constitution itself and what those words meant originally as they were understood. But as a citizen, I am free to go outside of the written Constitution. I am free to go to broader principles to make my judgment as to whether or not a particular law is ethical or is good in that sense. Clarence Thomas also makes that distinction, right? Thomas argues and discusses natural law principles quite readily, talks about them outside. But that doesn't mean that he goes to those kinds of philosophical principles to decide cases, rather than decide cases based on the text of the Constitution and the historical understanding.
Great, thank you. Janine, do you want to grab the last few minutes here to wrap up?
Okay, yes, I'm gonna let Jewel and Jordan ask the last question, but I just having a thought based on what you were saying. Gosh, and I lost it. It went away. Okay, so Jewel and Jordan, would you like to toss out the last question here?
Yeah, I have one thing that was pretty interesting to me recently. It was obviously Black History Month, and we got to see different MLK tributes again, and remembering that battle in our country. And then I watched a really good episode of an older sitcom where they talked about it as well. And I started to have this thought about the dichotomy between civil rights and natural rights. And today, when we say civil rights and we think about the civil rights movement, they were pretty direct in what they were asking for. Martin Luther King, and those were generally Christians, and there was some ecumenicalism, but in general it was a Christian movement, and they were asking the state to recognize natural rights that already existed civilly, civil rights. Today, a lot of our confusion is based around people asking for civil rights for whatever minority group they may be in, but the civil rights that they're asking for are not necessarily civil rights, and maybe they're not things that the government would necessarily be recognizing anyway, because they're not rights given by the government. So I guess part of my question was, if you were talking not as a maybe as a professor, but if you were just talking recreationally, socially, and you were talking to someone about civil rights or natural rights, and you thought it was important to make a distinction, how would you say it?
You know, that's a question or a distinction, comparison that's, again, been around for 2,500 years. If you go back to writers like Cicero and some of the Roman law writers, their distinction between natural law and civil law is that which exists universally and which is inscribed on the hearts of men, which is we can find in practice by looking at the different cultures and so on, what they do in particular circumstances, if there's a universality to it. Whereas civil law is that which is governed by the local civil authority, the civitas, right? So it's the peculiar local law. The city of Rome, when in Rome, do as the Romans do, right? It's a Roman law that tells you drive your chariot on the right side of the road or something like that. Today, our definition of civil rights is somewhat different than natural rights, but it also has a considerable overlap. When you read about civil rights, when Martin Luther King's talking about civil rights, he's basically talking about natural rights and principles of natural law, right? Universality, that sort of universality that exists wherever you might be. Human rights in a broad sense. But sometimes, if I understand you correctly, when we talk about civil rights today, we're almost more talking about having government do something for us, rather than having these protections against government violation. So that sense of civil rights is different from the classic view, or even the view, I think, that Martin Luther King represented.
Yeah, that's awesome. Go ahead, Jewel.
I was just saying that was an answer, just making sure you didn't think that I wanted something else. Thank you very much.
Yeah. Thanks, Jewel and Jordan. And wow. That's all I can say. This is a lot to think about. And what a great constitutional chat. Professor Knipprath, I bet you're exhausted.
Yeah, these are good questions. Excellent questions. You can have a whole seminar on this topic.
Right. That was a lot. And I just keep thinking, especially hearing Jewel and Jordan's questions and even our questions from the audience. I just keep, and your answers, in conclusion here, I think what a disservice we're doing to our nation's youth by not teaching them the classics in, say, middle school and high school, and the philosophers, and by not at least bringing up the nature of a creator in a non, specific religion type of way. That we're doing a real disservice, I think, because they're only learning the secular view. They're only learning the man is the measure of all things view. And instead of really having at least two perspectives. I think we're afraid now in our maybe not in college, but in our undergraduate arena, of at least talking about two different perspectives, that's really been shut down. And that's why I think you get students in your class that you don't even know if they know about the House of Representatives and the Senate. I mean, this is why we do what we do. Yeah. Anyway, thank you. I learned so much. Thank you, Professor Knipprath, as always.
Thank you for having me.
Thank you
very much.
And for your time. I mean, you really you're doing a great service for America, and I thank you so much. Okay, Jewel and Joerg, y'all rock. Aubrey, you rock, and Kathy, you rock. And our audience, thanks for joining us. We have three more of these. The next one's going to focus more on Kathy. You have the exact titles. We go over all this and religion, or go ahead and tell us the next three.
Well, our next constitutional chat is Tuesday, March 30th on morality in natural law. And then Tuesday, April 6th, we're going to talk about the founders in natural law. And then Tuesday, April 13th, we'll talk about preserving natural law today, why natural law matters to you. And we also want to give a plug for our book club. Currently, we are reading a book about natural law called Written on the Heart, The Case for Natural Law by Jay Budziski. And there's probably a better way to pronounce that. But if you go on our website and click on book club, you will find that book. And our book club is meeting Thursday evening, April 22nd at 7 p.m. Eastern. So this is the next 30 days. We are really focused on natural law, and we invite everyone to stay with us through this, because as you can tell today, there's a lot to learn about it.
And kudos to Professor Knipprath, who talked about all four of those subjects in 50 minutes. All right. Thank you, everyone. Join us again. Have a great day.
Bye.